Hello and welcome to the September 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm a partner here at Secrest Wardle's Troy office. Our September 2023 topics include, of course, a case law update. We'll be discussing the unpublished opinion of Ronnie Fields v. National General Insurance Company, which was recently issued on August 17, 2023. Then we'll move on to Evans v. Avis Budget Car Rental, also an unpublished opinion issued August 10, 2023. And then for trending topics in PIP litigation, we're going to be discussing the recent changes in case evaluation sanctions, and the to-be-published opinion of RAD Construction v. Davis. First up in our case law update is the case of Ronnie Fields v. National General Insurance Company, an unpublished opinion recently issued on August 17, 2023. Now, this case pretty much centers upon fraud and the Williamson decision. Here, plaintiff was hit by a car while riding a bicycle in Flint. Plaintiff sustained serious injuries, including multiple broken bones and lacerations, blunt force trauma to the chest and abdomen, and a traumatic brain injury, or a TBI. Now, plaintiff submitted 2 applications for benefits through the MAIPF. The first application was dated October 4th, 2019, and the second was dated a month later, November 4th, 2019. Upon commencement of litigation, the discovery process revealed that plaintiff's 2 applications for benefits were riddled with misrepresentations, so they were differed vastly. As such, defendant Nationwide filed a motion for summary disposition, and the trial court granted Nationwide's motion, holding that no genuine issue of material fact existed as to whether plaintiff committed fraud and was thus ineligible for PIP benefits through the MAIPF. Specifically, the trial court ruled that plaintiff violated MCL 500-3173A4 by knowingly submitting false statements in support of his claim for benefits. Now, several things were argued on appeal. First, plaintiff argued the case of Williamson v. AAA, a published opinion that any medical records or deposition testimony obtained after litigation was commenced could not be used to defeat plaintiff's claim for benefits. Specifically, this Williamson case held that the Fraudulent Insurance Act provision of MCL 500-3173A does not apply to statements made after litigation ensued. Next, plaintiff argued that the 2 applications for benefits submitted to the MAIPF must be considered inadmissible hearsay under Michigan Rules of Evidence 801 and 802. Lastly, plaintiff argued that defendant Nationwide could not show that plaintiff intended to commit fraud within the meaning of MCL 500-3173A4. Now, ultimately, the court held that medical records did not fall under Williamson umbrella because they were properly considered by the trial court. The statements at issue, or the application for benefits here, were made by a party opponent under MRE 801, and therefore they were not inadmissible. Now, I want to go back to that first argument that plaintiff made under the Williamson case, that the medical records or deposition testimony obtained after litigation commenced could not be used to defeat plaintiff's claim. Specifically in this case, plaintiff's applications did not indicate pre-existing injuries. However, plaintiff's deposition testimony and medical records show that between 2012 and 2019, plaintiff treated for complications arising from a dog bite and injuries sustained after someone struck him with a baseball bat. And that injury was specifically a leg fracture. Plaintiff also stated that he is legally blind, which was not disclosed on either application. Now, relying on Williamson, the Court of Appeals held that plaintiff's deposition testimony would constitute false statements made during discovery, and as such, the court held that plaintiff's deposition testimony could not be considered evidence of fraud. However, the court did find that medical records did not fall under Williamson and were properly considered by the trial court. The court noted that even though the medical records were obtained during discovery, the information contained in them concerned incidents that occurred well before plaintiff applied for PIP benefits. So that information did not take place, or that subject matter did not take place during discovery. The court didn't hold too much weight to the hearsay argument, but essentially said that the statements at issues were admissions by a party opponent under MRE 801 D2. But lastly, with regard to plaintiff's arguments that defendant Nationwide could not show that plaintiff intended to commit fraud, the court was not convinced that the trial court correctly concluded that no genuine issue of material fact existed as to whether plaintiff knew or understood the contents of the first application for benefits, which was October 4th. However, as to the November 4th application, the court stated that plaintiff merely argued that he did not know what he was signing because he was blind. Nobody read him the contents of the application, and the court indicated that no Michigan case law existed discussing whether legal blindness is sufficient to prove that an individual did not know or understand the contents of a document they were asked to sign. The court, moreover, discussed the case of Bakeman v. Citizens, where a person is presumed to understand the contents of a document if he or she has never even read it. Now, taken together, the Court of Appeals determined that plaintiff's medical records were properly considered by the trial court. Plaintiff's November 4th application for benefits was a statement of a party opponent and should not be excluded under MRE 8036 due to lack of trustworthiness, and that there is no intent element in MCL 500-3173A4. Moving on to the case of Evans v. Avis Budget Car Rental, an unpublished opinion recently issued on August 10, 2023. Now here, the Court of Appeals found that defendant, Avis Budget Rental Car, was entitled to summary disposition of plaintiff's claim because plaintiff was unable to present evidence to show a genuine issue of material fact with respect to whether plaintiff was willingly operating or willingly using motor vehicle or motorcycle that was unlawfully taken by someone, and the person seeking benefits knew or should have known that that vehicle was taken unlawfully. Now, by way of background here, plaintiff was involved in a motor vehicle accident while driving a rental car that his then girlfriend had rented from Avis. Above the signature line on the rental agreement was language stating, in pertinent part, no additional drivers allowed without prior written consent. So therefore, it was undisputed that plaintiff's girlfriend never attempted to obtain such consent or to have plaintiff listed as an authorized driver of the rental car. There was an accident, and following that accident, plaintiff sought PIP benefits through defendant as the no-fault insurer of the rental car. And then following discovery, defendant, of course, moved for summary disposition under MCR 2.116C10. Now, ultimately, defendant asserted that there was no genuine issue of material fact concerning whether plaintiff was entitled to recover PIP benefits because plaintiff had unlawfully taken the rental car and was not listed as an authorized driver under the Avis rental agreement. Now, remember, plaintiff's girlfriend is the one who rented the car. She obviously signed the rental agreement, and she did not list the plaintiff here. Defendant further argued that plaintiff knew or should have known that the vehicle was taken unlawfully, and in response to that, plaintiff alleged that there was a question of fact regarding whether his conduct constituted an unlawful taking under MCL 500-3113 because plaintiff had no reason to believe that he lacked authority to drive the rental car, as his girlfriend consistently rented cars for the past several years for plaintiff's specific use. Ultimately, the trial court granted defendant's motion, determining that there was no genuine factual dispute regarding whether plaintiff had unlawfully taken the vehicle rented by his girlfriend, or whether plaintiff knew or should have known that the vehicle had been taken unlawfully. Now, on appeal, the court addressed two main issues. One, whether plaintiff's use of the motor vehicle rented by his girlfriend constituted an unlawful taking, and two, whether defendant demonstrated facts to determine that plaintiff knew or should have known that his operation of the vehicle was actually unlawful. Now here the court discussed the case of Ahmed v. Tokyo Marine American Insurance Company. This is a 2021 Court of Appeals case which established a three-pronged test to evaluate claims under MCL 500-3113A and determined that the disqualification applies to any person willingly operating or willingly using a motor vehicle that was unlawfully taken by someone, and that person seeking benefits knew or should have known that the motor vehicle was taken unlawfully. So that's the three-pronged test to apply to this set of facts. So therefore, in applying the Ahmed test to determine whether a taking is unlawful, a breach of a vehicle rental agreement between two parties is conclusive proof of a party's unauthorized and therefore unlawful use of a motor vehicle. Also, if a rental agreement requires authorization, either express or implied, it must be given by the vehicle owner, here the rental company, and not the renter or plaintiff's girlfriend. And therefore, the language of the rental agreement here is binding in determining who is authorized and who is not authorized to rent the vehicle. And moving on to our last section today, trending topics in PIP litigation. Now here I wanted to discuss case evaluation sanctions and the RID Construction Insurance v. Davis case, which is to be published. Now, as we all know, effective January 1st, 2022, the Michigan Supreme Court instituted significant changes to our case evaluation rule. One of the most significant is the elimination of sanctions penalty for parties who reject the case evaluation award. Now, previously, the rejection of award would expose the rejecting party to sanctions, including payment of the party's actual attorney fees, unless the rejecting party improved its position by at least 10% at the time of trial. So this was effectively eliminated January 1st, 2022, and the court rules now are silent on how or if this change affects cases that were pending before the rule change, as is the case in the RAD RID construction case. So that would be cases before or prior to January 1st, 2022. Now, of course, this case addressed the issue of case evaluation sanctions and whether they should be awarded to a party when trial occurred after the Supreme Court's amendments to MCR 2.403 took effect, but case evaluation here took place before the amendments were implemented. Now, by way of background, the RID construction case arises from the settlement of an insurance claim following a kitchen fire at a home owned by defendants Del Reese and Latasha Davis. And although this isn't a PIP case, the case evaluation sanctions obviously still apply. And as we all know, PIP cases have this same exact set of facts right now that are currently pending, where the evaluation took place before the amendments were implemented. However, trial is obviously occurring subsequent to the amendment. Now here, after the fire, defendant Davis entered into a contract with defendant Integrity, which is solely owned by another defendant, Boyd. Now, just to speed this up, as this is not a PIP case, the parties here engaged in case evaluation during January 2021, and RID rejected the case evaluation award on February 9, 2021. MCR 2.403 then provided that if a party has rejected the evaluation and the action proceeds to verdict, that party must pay the opposing party's actual cost unless the verdict is more favorable to the rejecting party, and that's by 10%. This case went to trial, and RID did not obtain a more favorable verdict when the trial court rendered its opinion an order on April 12, 2022, dismissing RID's claims by Chase Bank, Integrity, and Boyd. And then the trial court entered its order granting the defendants sanctions on September 7, 2022. Now, ultimately here, as we all know, the amendments became effective January 1st, 2022, and according to MCR 1.102, it requires applying the court's rule to all pending cases. Therefore, given that the Davis matter was still pending, because all pending cases, when the amendments to MCR 2.403 took effect, the Court of Appeals found that case evaluation sanctions could not be awarded to the parties, Chase Bank, Integrity, and Boyd. The court also said that amended court rules apply to pending actions unless there's a reason to apply the old rules, and that's the case of Redmeyer v. Schultz. So as such, the court found no reason to apply the old rule in this case because there was no reason to do so. The Court of Appeals opined that because the provision authorizing case evaluation sanctions had been eliminated, the trial court had no authority to sanction RID after January 1st, 2022. So here, this Davis decision further cements that case evaluation sanctions are a thing of the past, long gone, and ultimately makes the important point that if a matter was pending at the time of the amendments, case evaluation sanctions cannot be awarded. And that is all I have for you guys today. My name is Amber Rouse Holloway, and as always, I welcome any questions and or concerns. Thank you.